Harts Webinar. I'm delighted to be joined by Emma Fay of HR Department Wilmslow and various other HR departments now, as she's expanded her business, and no doubt she'll tell us all about that as well. As always, this will be recorded and will appear on our YouTube channel later on. If you didn't know we had a YouTube channel, then you do now. There's plenty of information on there going back about 4 or 5 years on various recordings of various other things that we've done over the last few years or so. Lots of interesting information, new videos, stuff does get updated, so watch out for that. As always, we have to start with our usual disclaimer. So the following presentation is produced for general guidance only, and professional advice should always be sought before any transaction is undertaken. Individual circumstances can vary, and therefore no responsibility can be accepted by Harts Limited or any of their affiliates for any action taken or any decision made to refrain from action by attendees of this presentation. Okay, other online resources, you can follow us on LinkedIn. We're delighted if you would do. You'll see lots of information coming out on there as well. We're also on YouTube, as we've already talked about. Follow us on X. Lots of people seem to move from X at the moment anyway. And then we're also on Spotify, because we have a number of podcasts which are available on Spotify where we have interviews with business owners, and to see what they've done, how they've done it, the challenges they've faced and so on, and how they've overcome them. If you want to be interviewed as a podcastee, then feel free to give me a call and we'll be able to sort something out for you. Our next events, well, we will be continuing our webinar series in 2025. So any suggestions, please let me know.
I'm on an employment law webinar. No, don't be daft, you're not supposed to. Can I call you back?
So why not join us for, also we have our business club. These are lunches and networking throughout 2025, all held at Holland Hall Hotel in Bollington, and the next one is in March. If you want to have a look at those, go to our events page. The dates will turn up in the new year and be able to book on. We normally have about 50, 60 people at these. It's well worth coming along to do some networking. They are joined within the North Cheshire Chamber of Commerce and Orbit Developments, so feel free to join us on those. Well worth a visit. Quick update. Yeah, we've had a budget, and I'm sure there's a lot of business people here who are not going to be overly happy about what's gone on. There is a petition, if you want to sign it, for a new general election, which is attracted over 2.5 million signatures. Quite whether that will work or not, I sincerely doubt. But having looked at the budget, have you considered the inheritance tax implications for you? Have you considered the national insurance contributions, extra payments that you may have to make? We've been doing calculations for a number of clients. The most we're up to now with extra NIC contributions is about 100,000, including the increase in the minimum wage. So it can have a significant effect on your business. If you want us to have a look at what sort of effect that's going to happen come April next year, then please feel free just to get in touch. Also, don't forget that pension pots are now going to form part of your estate for inheritance tax. And it's not just the farmers that are going to struggle with the business, with the agricultural property relief. It's also business property relief which gets hit. So if you have a big value on your business, then it will affect you. It's not just the farmers, it's any business. And finally, we are coming into self-assessment season. We are in it at the moment. We are already busy doing them. So if you've not had your self-assessment return done yet, please feel free to get in touch. One final thing on the budget, double cab pickups, it was hidden in the budget detail. Those are going to be treated as cars from April next year. So benefit in kind rules change considerably. Unless you've already got one, you'll be able to continue on with that. But it will change for us for 4 years or so. Okay, I'm now going to hand over to Emma Fay, who is going to talk about all the employment laws, changes, what we need to know, how we can help ourselves, etc., etc. So over to you, Emma.
Thank you. How we can help ourselves, I'm not sure. We'll find out together, I guess. Can I just check you can see the screen?
Yeah.
Great, lovely, right. Yes, good morning, everyone. I'm Emma. I run 2 HR companies, albeit under the same brand, which is the one on the screen here, the HR department. We are a franchise, that's why I've got 2 of them. That's only quite a new development, as Stephen mentioned. So HR department Wilmslow I've run for 10.5 years now, so covering Wilmslow, Alderley Edge, Poynton, all those kind of areas. And yeah, about a month ago, I inherited or acquired HR department Trafford and Warrington. So we now have a much bigger area. There's 7 of us in the team. So there's about 5 of us doing the HR support for our clients, as much or as little as they need. And then we have 2 wonderful business support ladies as well, who keep us all very organised. So what I'm going to talk about now is the Employment Rights Bill. The original name of this presentation, when I did it back when we had the King's Speech, was the first 100 days, but we're well past that now. So let's go through what I'm going to cover in the next 30 minutes or so. I'm going to talk through what the Employment Rights Bill is, first of all, and then I'm going to focus on 6 of the key areas. There's a lot more than 6, I'll just put it out there, but we haven't got all day. So the 6 key ones that actually we're getting the most questions about, that are maybe causing the most concern in some cases, we'll go through those in a bit more detail. I also want to just run through some of the things that were actually omitted from the bill when we saw the draft, and what we think might happen on those points. But importantly, thinking about how we can prepare for these changes. There's going to be an awful lot of change. We've not actually seen that level of change in employment law for a long time. I think the idea is about 50 years since like unfair dismissal and things actually became law. That was a huge time. We haven't really seen the same kind of change since. So it's going to be big for all of us. So important to just keep ahead and know what's coming and when, and how we can actually mitigate the impact of the changes on businesses as well. So first of all, what the Employment Rights Bill actually is, just a little bit of a timeline. So back when the election was going on, Labour were promising all sorts of things, and the main promise around employment law was their plan to make work pay, as they called it, and they promised to implement that plan within 100 days of being elected. That obviously didn't happen. What they did do, though, is put draft legislation before Parliament on the 10th of October, which was just about within the first 100 days. And that was kind of the moment where we were thinking, great, we're all going to be really clear about what's going to happen. Sat and read through a rather chunky bit of legislation, draft legislation, which is actually bigger than the Employment Rights Act itself. So it's quite a lot of reading. And we all kind of come out of it scratching our heads, wondering what is going to happen. We're not any clearer, really. There's too much detail missing. But we at least know what the priorities are, because there's, like I say, some things omitted from the draft legislation. It is a very much watered down version of Labour's original plan. There's not really any surprises there. It happens, doesn't it, in terms of what's promised and what's delivered. But there are promises to introduce further things later down the line. So this Employment Rights Bill is maybe to be seen as the first part of Labour's proposed employment changes. Still very much being discussed in the media. There was something on the radio just this morning about it, because there is this huge shift in workers' rights, which is going to have a huge impact for business, particularly small businesses, in terms of cost, admin and risk, litigation risk as well. So still lots to be discussed, but where we're at the moment, the bill is currently at the committee stage. In the legislative process, there's been a lot of criticism over the impact assessment that's been carried out by the government on this bill. That only came out yesterday in an email that I saw, where there's a lot of criticism about actually what's been considered and what, more importantly, hasn't been considered by the government in terms of the impact of these changes, not only on businesses but on workers as well, because costs are all going to go up and employment will be affected. There's lots of really significant impacts. So we're just going to have to see how we go, but there's consultation continuing. It's going to be continuing throughout 2025. And the expected implementation for most of these changes is 2026, which means we have got time on our side, which is one of the positives, if there is one in this situation. The change to unfair dismissal rights in particular, Labour have said that won't happen any earlier than October 2026, so a good kind of 2 years away. So it does mean we've got lots of time to prepare, but also lots of time for more details to be coming out. So we imagine over the next 2 years, it's going to be quite a challenging time just in terms of keeping up to date with what's going on and when and what different implementation dates are likely to come into force. So these are the 6 key areas that I'm going to cover in more detail. I'll do a little bit of a mopping up after these 6, and I also do want to do an update on a non-labour thing, because it is important employment law change that happened recently. So let's get started with these 6 then. We have 0 hours contracts first of all, and back when we were here in the early stages of these proposals, it was all about banning 0 hours contracts altogether. It's been watered down to banning exploitative 0 hours contracts. So Labour are very much about removing what they call one-sided flexibility. So those contracts where perhaps they are 0 hours in name, but not 0 hours in nature. So those that actually do exploit individuals, because actually 0 hours contracts used properly are very good contracts. I'm a big advocate of 0 hours contracts. I've got 0 hours workers in my team and they work very well, but it's all about two-sided flexibility. So what the Employment Rights Bill does say is that there will be a requirement on employers to offer a permanent guaranteed hours contract to 0 hours contract workers after a qualifying reference period, which they haven't actually stipulated in the bill what that reference period is, but we expect it to be 12 weeks. We just need regulations really to confirm that that will be the case. So effectively what we'll see is every 12 weeks, employers need to look at how many hours the 0 hours person has been doing, sit down, offer them a guaranteed hours contract that reflects that working pattern, whether that's 5 hours a week, 10 hours a week, 40 hours a week. The key thing is that the employee or the worker could refuse that contract, so they can choose to stay on a 0 hours worker contract, which is actually quite a relief, because there was an initial worry that this would be a mandated thing and we would have no say in the matter, nor would the worker, whereas a lot of 0 hours workers actually value the flexibility that they have. The further change is that workers will be entitled to reasonable notice of a change or a cancellation of shifts, and if that reasonable notice isn't given, they will be entitled to compensation. Now, we don't know what the compensation is and we don't know what reasonable notice is. So this is an example of the bill just not being clear enough for us to give good advice on it at the moment, but we will be looking out for those further regulations. But in terms of what it means for business at the moment, excuse me, what we really need to think about is whether 0 hours contracts are the right way to go. As I say, in some cases they absolutely are, but in some cases they're not, and there are other options. We can be quite creative with contract writing in terms of having flexibility built into actually guaranteed hours permanent contracts. We can use things like annualised hours contracts where the hours are reconciled over a longer period. We can also use short-term or fixed-term contracts if it's about meeting a seasonal peak in demand, for example. So making sure that we're not just defaulting to a 0 hours contract because we think it's the only option, and thinking about what else might be more suitable to the scenario. Of course, if this does come in, we're looking at increased admin, increased costs. If someone has got to be responsible for monitoring those hours, looking at people's hours over a qualifying period, sitting with the individual, talking about the contractual terms, offering them a contract, that all takes time and costs money. So there is going to be an impact there. As I say, the devil will be in the detail. We just don't know what the reasonable notice is or what the compensation is. But we will need to be a bit more forward thinking in shift planning and things like that, so that we can better prepare or better mitigate the risk of those shift changes. Obviously, in some sectors, we know that that's just not possible, hence the need for 0 hours contracts in the first place. But the more we can do to have good forward planning, the better on that. So that's 0 hours contracts. We then have changes to sick pay, and this is effectively just making sick pay more available to more people. So they plan to make SSP available from day 1 of absence, so removing the current 3-day waiting period where there's no pay due. The lower earnings limit, which is currently £123 a week, that'll be removed, and that makes SSP available to all employees pretty much. So There are impacts to that. Obviously, there's a cost increase. So making sure that we're aware of what that cost is likely to be based on your average absence rates, particularly those businesses who mainly only have very short-term absence, so people taking 1 or 2 days off who currently wouldn't get any pay for that. There is going to be an increase in cost there. It could also mean, and I'm not sure about this myself, but it could mean that sickness absence increases as a result, because there's not that unpaid period at the start. However, my view is sick pay is so low, it's not exactly enticing for somebody to take a full day off when the pay is as low as it is. But it could change things. It could change perceptions, whereas at the moment, maybe the perception is, well, I won't get paid if I have a day off. Maybe that'll shift to, oh, well, I'll get a bit of money at least. So we could find that absence management challenges do increase once this changes. We will then need to make sure that our policies and processes are updated and make sure they're in place to start with, but make sure they are updated to reflect the current statutory sick pay rules. Make sure you've got things like reporting mechanisms in there so that staff are very clear about what they have to do when they're off sick. Also, maybe thinking about trigger points in your absence management policies. Absence management is just going to be more of an important thing. It's important anyway, so it's good things to do. Make sure you've got trigger points, you're monitoring absence, and you've got a system for doing that. Maybe a system that flags when absence is a problem. And just thinking about how we deal with people who are maybe taking too much time off, or where there are patterns emerging in their absences, whether they're having quite frequent Mondays off or whatever the pattern may be. We're going to need to understand how we manage that and how we can quickly rein it in if there is a sudden increase in absence. What
would you suggest if people do start saying, right, I need a day off, or taking a Monday off, or they're taking a Friday off, and it's the pulling a sickie basically? How do we get around that problem?
So some really good things I would recommend is, obviously, first of all, is having your absence process in there so that people are very aware what's going to happen when they are off sick. And one of the things I suggest should happen every time someone is off sick is a return to work meeting. Going through actually a standard pro forma where you're actually going, right, when was the last time they were off sick? Oh, that was a Monday as well, because that can really help you actually realise that there's a pattern. Asking people whether this period of absence is linked to a previous period so that we can understand as well, is there an underlying health issue going on that we probably need to know about and can mitigate the impacts of. But also making staff aware that we are on it and we're monitoring it and we're going to have conversations. So having those trigger points in a policy is really good, because if you use, for example, a Bradford factor trigger, or any other kind of trigger is fine as long as it's clear what it is. People know that you're going to have a meeting with them when they hit that trigger. So I'm not suggesting we dismiss people when they hit a trigger point. We don't do that, but we certainly call them in for a conversation to say, hang on a minute, you've had, I'll give an example that is a real one, 14 Mondays off in the last 6 months. Yeah, 14 Mondays, and it hadn't been spotted because it was just like, oh, he's having another day off, he's having another day off. And then when we sat down, I was like, these are all, I think, no, one of them was a Tuesday, but the others were Mondays. Actually making sure that people know we're spotting those things, because if staff think we're not looking at it, we know what happens with that. So
yeah, that does help. We've had one other question as well, just going back to 0-hour contracts. If the 0-hour contract is managed through an agency, who is responsible for offering the contract, agency or end employer?
It's a good question, and that came up actually in a previous talk I did on this, and we don't know is the answer. I would hazard a guess it'll be the agency. That's what my understanding would be, just because of who the employment relationship is with. So that would be my guess, but we will find out, I'm sure.
So watch this space, basically.
Yeah, absolutely. Yeah, so final bit on the sorry, I can't see the questions as well while I'm
okay, it's no problem.
Do just interrupt me if I miss any. Yes, final bit on this is maybe if we're thinking that there is an issue with sickness absence, is the potential to actually use more flexibility to reduce that. So can we be a bit more flexible with working hours? Again, some industries, yes, we can some not so much. So that'll all very much depend, but it's maybe just thinking again a bit more creatively about how we can solve these kind of problems as a business. So unfair dismissal, this is the real fun one. Unfair dismissal rights from day one. So this has never been a thing in this country. We've never had a situation since unfair dismissal actually became a right to not be unfairly dismissed. It's never been a day one right. There's always been a qualifying period. You may remember it used to be a year. It's now 2 years. So we have 2 years worth of leeway effectively, where as a business, if something isn't working out, we don't have to go through the whole process, disciplinary capability, redundancy, whatever it may be, to dismiss. We can follow a shortened version of that. So as you probably all know, the government have said they're going to get rid of that 2-year rule, which is a huge problem in many ways. But they are consulting on a statutory probationary period. In the legislation itself, there's no mention of probationary period. It was one of the first things I did a search for as soon as I opened the draft bill. I'm like, where does it talk about probation? And it doesn't. It mentions an initial period of employment. I think there are reasons around why they've not called it probationary period, because probationary period is already a thing and it doesn't have any legal meaning. So potentially to just avoid confusion, they've referenced it as an initial period of employment. There's no mention of what that initial period is in terms of duration, but we understand that the government's preference is 9 months. That's following consultation. We've had people within our franchise go off to sit with Angela Rayner and discuss these proposals. It was initially 6 months. We think they're now sitting at 9 months. So we still don't really understand what that means. So we're very certain that if there's a 9-month initial period or probationary period, whatever we're calling it, there's less requirements to dismiss somebody, but we don't think it's going to be no requirement like it is now, where we don't even need a reason to dismiss somebody within the first 2 years. We think that all the statutory reasons for dismissal, the 5 fair reasons for dismissal, will apply from day one. We will need to follow some kind of process. So in terms of what it means, those quick short service dismissals will no longer be an option. It is a problem. We get a lot of dismissals where someone's offered a job, someone's either not turned up on the first day because they've changed their mind, or they just haven't bothered getting in touch to say that they can't come in, and we normally would dismiss the person. It's a very clear red flag indicator, unless if something genuinely really has gone wrong for that person, to stop them coming into work. Under the new law, we wouldn't be allowed to do that. We'd have to invite them for a disciplinary meeting and have to follow that process, whether it's a shortened process or not. So those short service dismissals that we do an awful lot of, we will, and I say we as a HR company, not suggesting we're all just dismissing people, but those won't be an option. We'll need to have good processes for every single dismissal. So recruitment is going to become more important, making sure that we're actually putting a lot of thought into the recruitment process. There's lots of good stuff we can do to actually improve recruitment, so that we're not panic hiring, getting the body through the door and then realising it's not working out, so we need to get rid. Because at the moment we can do that, and it's relatively easy to do that from a legal perspective. But we need to make sure now we're thinking about how could we improve our recruitment to reduce the chance of the wrong person getting in through the door. Making sure as well that we're utilising probationary periods. So you may already have processes in place where you do mid-probation reviews, end of probation reviews. Make sure you've got good induction processes in, and you've got monitoring tools in from the very first day, so that if it's not working out, we're managing it from day one, which should, whenever this law changes, post October 26, whenever it's going to be, we know that we've got those mechanisms in place so that we can manage performance, we can manage conduct, and those dismissals can happen, but in line with the new requirements. So like I say, we are awaiting details, as with most of these things. We don't know what the rules are around probationary periods, but you will likely have to follow a more stringent process for any kind of dismissal. And that also means that managers need to be well equipped, they need to be trained to properly manage performance from day one, and they need to understand the legal risks if they are currently in the habit of dismissing quite easily. So it is a massive shift for all of us, including us in HR. It's one of the very first questions that we ask when a client calls us up. How long have they been there? So it's going to be a big shift for us as well. So one to definitely watch this space on with regards to how those probationary periods might work and what those requirements will actually be when the law changes. So flexible working, this is a developing area of law anyway. There was already changes in April this year to make flexible working more available to more people by moving it to a day one right, and people now have the option to request flexible working twice in a 12-month period, so that was a change as well. But Labour are looking to effectively widen that even further. It's more of a shift in emphasis than anything in terms of what the Employment Rights Bill says. So we already have a situation where someone can request flexible working from day one, and they have the right to have that request properly considered. And there's only a number of legal reasons as to why we can refuse a request as a business. So that we don't think is going to change, but the emphasis will shift to the business having to accommodate that request unless they have a reasonable business reason not to. So that's the shift of emphasis, rather than the current situation, which is sometimes, I'm not suggesting this is all the time, but sometimes it's a case of, we've got this flexible working request, how can we refuse it? Trying to find one of the reasons that fits. We'll be shifting that to how can we accommodate it. That'll be the shift.
Sorry to interrupt, does flexible working include working from home?
Yes, it does. So yeah, flexible working is any change to the contract in terms of how the person carries out the work. So it can be a change in place of work, such as a request to work from home. It can be the opposite, a request to work in the office for someone who does work from home. We've had some of those recently, which is interesting. We can also have requests from full-time to part-time, job shares, those kind of things. So anything where someone is trying to change their contract.
So if in theory, if you have a junior who's joining you and wants to work from home, and you know that that's not going to be for the benefit of them or the firm, can you insist on saying no?
So you would need to have the business reason, rather than it being that we think it won't work. We understand that the current position will stay the same in relation to trial periods. So currently with the flexible working regulations, you can have a 4-week trial period if either party isn't sure whether it's going to work. And that can actually be a really good way to test it out, because if then it doesn't work, you've got evidence that you tried and it doesn't work, there's detrimental impact on performance or whatever it may be. And we can demonstrate that. So I think that's going to stay the same, albeit it's not confirmed. But if we are going to refuse it, we'll have to put that business reason clearly in writing with full details as to what we've considered and why it absolutely won't work. So yeah, in that example of a junior who wants to work from home, we would need to be able to demonstrate that it's not a preference of ours, it's a genuine
business case.
Yeah, absolutely. So again, I think it's a bit of a change in mindset. I have a good example of this, which is actually a staff member of mine who I took her on a hybrid basis. So she was about 2 or 3 days with me, the other 2 or 3 days from home initially. And about 6 months after starting with me, she told me she was moving away, about an hour and a half drive away, which she doesn't drive. So that was a big change. And my view at the time was very much, this isn't going to work. This isn't a home working job. It's not a remote job. I need hybrid. I said I'd try it out, and I did. And we're 3 years on, and she fully works from home. And it did work. So it was a good kind of lesson to myself to actually just sometimes be open-minded and try it out. You never know. And if someone really wants the home working, they're going to probably try and make it work and do a good job. So when this changes, you might start. Oh, I can hear myself. That's odd. When this changes, you might start getting additional requests. We saw a bit of this when the law changed in April this year. We saw a little bit of an influx of flexible working requests because it becomes more widely known, it gets on the radar, and people start putting in those requests. So you might start seeing that increase in the run up to the law changing anyway, just because it's been talked about. And making sure that you've got those reasons. We haven't got the definition of what the new reasons will be. There's currently, I always forget whether it's 8 or 9, I think it's 8 statutory reasons to refuse a request. Those are already there. You can find those on the ACAS website and things like that. So what the government haven't clarified is, will those reasons change? But the indications we have at the moment are on the screen there, that the reasons will include things like the burden of additional costs, detrimental effect on ability to meet customer demand, inability to reorganise work or recruit additional staff, impact on quality of performance, or insufficient work when the period that the employee proposes to work. So we've had that where someone has tried to shift their working pattern towards more of an evening, and actually we're saying, well, we don't have work during that period, so we can't accept it. So actually the reasons are very similar to what we have already in the law. So don't think there's going to be too much of a change there. Apologies if you just saw the cat. Ensure your flexible working policies are up to date. They should have been very recently updated for this year's changes anyway. So make sure that as and when this law develops, those are kept up to date and managers are aware as well, because we do sometimes see managers refusing flexible working requests out of hand, and it's just because they didn't realise it was actually a legal right and that there is a statutory process to follow. So make sure you know what that process is. Get the flexible working request in writing, make sure there's a meeting to discuss the request, and make sure that all considerations are given. And you can negotiate on requests as well. So if actually the request that the person has put in won't work, but something in the middle maybe could, that's absolutely fine to talk about that during that consultation process.
One other question which has come in, going back to temporary contract dismissals, how would it affect temporary contracts, either a defined duration or going from temporary to permanent in relation to unfair dismissal?
Again, it's a really good question, because at the moment we have a situation where a fixed term or temporary contract that goes over 2 years, we have to follow a full process to dismiss it. We can't just do your contract's ended, off you go. It's still a dismissal in law. So we have a weird situation where any fixed term contracts that consecutively run for more than 2 years are a little bit pointless, because we don't have the option to just end the contract. So that's what we imagine will be the case when this law changes, that even the end of a temporary contract or fixed term contract will be a dismissal, and we will need to follow those processes. So it could actually change the way that we do that. I'm going to move the cat because she's a bit disruptive. Yeah, so it could actually change whether those contracts are worth using or not. It'll be interesting to see whether they actually cover that in the regulations.
Okay.
Right. So further parental and bereavement rights. So Labour are proposing that all paternity and parental leave rights are to become available from day one of employment. Currently, there's a qualifying period of 26 weeks to be able to take paternity leave or parental leave. So that will change to become a day one right. And all employees will have access to bereavement leave. So currently there is only the right in law to parental bereavement leave. So employees who lose a child. So that's going to be widened to all bereavement. We're probably still going to see either 1 week or 2 weeks. I think the lean is towards 1 week bereavement leave for all employees. There's no clarity on whether that's paid bereavement leave or not, but if we go off what parental bereavement leave is, it's statutory pay. So we imagine it might be statutory paid bereavement leave. So more to come on that. And we're also going to see more protection from redundancy and any dismissals for pregnant women and employees returning to work from maternity leave. So this is already, again, a very much developing area. We again saw strengthening of those protections in April this year. So it's not necessarily a new or a Labour initiative, it's just Labour tightening what's already been done. So effectively it will, from what the legislation says, it will be unlawful to dismiss someone who is pregnant or returning to work from maternity leave, except for exceptional reasons. We just don't know what those exceptional reasons are. We imagine like gross misconduct, you'd be still allowed to dismiss somebody. But we're not sure what those exceptional circumstances are going to be. So it's something that would mean you'd need to be very much aware of. It's unlikely to impact day-to-day business running, but it is something that you need to be aware of in terms of if there are business changes. There's already a very high risk if you make anyone redundant who's pregnant or returning from maternity leave. There's already a massive risk there, so I'd always recommend legal advice in those cases. But it means that not only in redundancy situations, but any reason where you might need to dismiss someone, in those circumstances, you're going to need to be very, very careful, because those people are going to be heavily protected in the law. Again, it's a case of keeping policies up to date, making sure that everybody's aware of those changes as and when they come into play, and potentially consideration for workforce planning as well, with regards to paternity and parental leave becoming more widely available to those employees who are joining the business. So again, just make sure that everybody in the business who might have any responsibility for dismissing, they know about this, because the amount of issues we see where it was just a lack of knowledge, it wasn't intentional flouting of the law, it was just didn't realise that it wasn't allowed. So just make sure that managers are aware of these things.
I think that's a lot of cases where the problems arise, isn't it, through ignorance rather than through any deliberate action. So again, to everybody on the call, it's just a question of, as Emma says, just being aware more than anything else.
Yeah, absolutely. We often say that, when we see tribunal claims come in for clients, I don't think I've ever seen one for one of our clients, and I am a bit biased, but I've never seen one where it's actually the employer did something horrendous, or they just were very, they didn't care what the law was, or they didn't care about employee rights. It normally is that they just didn't know. And that's the key thing. They didn't know, or the manager who did it didn't know. So yeah, awareness is key. A few other things, I will just rattle through these because these are, there's not a lot of detail. So this is why I've shoved them on the end, because there's not much mention in the actual legislation. So trade union law is going to be changed. It'll effectively be much easier for trade unions to have access to workplaces and to recruit members and to form in the first place. So those organisations where there isn't currently any trade union activity, which is the vast majority of our clients, there's likely to be an increase in that union activity, which isn't necessarily a bad thing. Unions can be really helpful when it comes to things like consulting with employees, informing employees of their rights and things like that. That can actually be really helpful. New enforcement body, we know nothing about this, but what they have said is that the Fair Work Agency will be formed. The rumours were that it's going to be an agency that can come in and investigate, make sure that employers are upholding employment rights. They've got policies, they're doing the right thing. So rather than it just having to be reliant on employees going to tribunal, which is the current situation, there'll be this body who has some power there to enforce employment rights, but we don't know anything about it. So whether that's going to happen in the next few years or whether it's just going to keep getting kicked down the road, we don't know. There's going to be changes to how minimum wage is set. So the government wants to remove the age bands. They want to flatten it. It is a bit discriminatory at the moment to have people paid differently according to their age. So that will be looking to change. But for the time being, it's not. We just have those minimum wage increases that were announced in the budget. So
I know we're looking at it from our clients' points of view, is kind of saying, well, why should you take on an apprentice when you can take somebody else on who's got 2 or 3 years worth of work experience, and you're going to pay the same wage? So whether that's cutting off your nose to spite your face, I don't know, but that's the feedback that we're getting from clients as well.
Yeah, and it's funny actually, because when I did this talk a while back, I said, I think there will be a void in particularly graduates where they've got the qualifications, they've got no work experience or very little work experience. They're going to be paid the same as the very experienced individual who's been in the workforce for 10 plus years. They're going to cost the same. Why would you take the risk on the graduate knowing you can't dismiss them easily? And you've got to pay them the same. So I do think there's going to be an impact there, like you say, Stephen, that there's going to be a void of people who are going to really struggle to get into the workforce. So yeah, interesting. And I do wonder whether they will change it for apprentices, whether apprentices will still be differentiated in some way, because they do get the training, don't they? So there is a good argument to differentiate.
Remains to be seen. Yeah,
it does. Yeah. So we'll all find out together. Key things that were just omitted then from the bill. There was the government's plan to create a single worker status. So I was mentioning like 0 hours of workers before. Currently in employment law, we have 3 types of status. We have workers, employees, and we have self-employed. It differs to tax law, which is you're either an employee or you're self-employed. So there is a lot of confusion. It causes all sorts of problems. But the worker status does cover that casual worker, 0 hours worker category. So to get rid of it, which is what the initial proposal was, would be, it's a massive thing, and I don't think they thought about it at all because it's not mentioned in the bill. I think it's going to be a much later down the line thing to tackle, if at all, because to actually flatten that into 2 categories, there's all sorts of implications. So still being consulted on as far as we know, but I wouldn't expect anything soon on that. The right to switch off was mentioned. I'm not sure about the requirements for this really, in terms of employees having the right to disconnect from work. Apparently this isn't going to come in any kind of legislation now, even though it was meant to. They're suggesting that this is going to be via a statutory code of practice. We'll wait and see whether there's any guidance on that, but whether it is a real problem that needs addressing, I don't know.
No, and that's presumably not accepting emails outside of work time and weekends and holidays, that sort of thing.
Yeah. And I mean, places seem to really do it anyway, I don't know, it's a weird one. I'm not sure what the problem is that's trying to be addressed there, to be honest. Okay. If people don't want to look at their emails, in most cases they don't have to, but yeah, it's I guess one of those blurred line things post-pandemic where work has blurred over into personal, but whether employees are genuinely concerned about it, I don't know. And then, yeah, there is a pledge to conduct a full review of the parental leave system as well as carers leave. So carers leave is a relatively new thing that came in this year in April, the right to take unpaid carers leave. There was going to be a raft of changes to all of the different types of parental leave, but that's been, again, kicked down the road. Now we've just got a pledge to do a full review. So we'll find out what the outcome of that is. And the government are consulting on expanding the Equality Bill. This is about changes to the Equality Act. We, again, don't really know what it is that they need changing because the initial proposals, they're already covered in the Equality Act. So again, I think they've maybe realised that there isn't much needed in a draft bill, but that is going to be produced anyway for scrutiny, but I wouldn't expect that in the next 2 years. It's probably going to be much later down the line. So knowing what the key things are, random QR code, that's not in context at all at the moment. We'll talk about that in a moment. But key thing is how we can prepare. So whilst these things aren't coming yet and not next month or anything like that, we really should be acting now, making sure that we're future-proofing our businesses, making sure we're ahead of the changes. So whilst we don't have the full details, we need to know that we've got good sources of those bits of information as and when they come out. It's very hard keeping on top of all these things, so just make sure you've got your good sources there to keep you up to date and your business up to date. Make sure that you review what you've got in place at the moment, so your contracts, your handbooks, your procedures. It's good to understand what you've got now so that you know what you will need to update when these things do start coming in. If actually you don't have any policies and procedures or handbooks, now is probably a good time to start getting those in place because it's much easier to tweak what you've got rather than completely start afresh in amongst a load of change. That's going to be a bit chaotic. So making sure you're prepared and as organised as you can be really ahead of these things coming in. Recruitment and onboarding. I mentioned particularly for the unfair dismissal part, getting the right people is just going to become even more important than it is now. It's already important. It costs a lot to hire the wrong person, as I'm sure you know, but making sure we're doing that even better. We're putting a lot more thought into the recruitment process. We do a lot of values-based recruitment stuff now, making sure we're recruiting for a good fit. We can train skills and things afterwards. So actually maybe getting the right person from an attitude perspective is a bit more important. And make sure we've got those processes for probationary periods as well. Making sure that we start shifting that mindset. So if we are in a position where we need to do a short service dismissal, actually what could we do differently what would we do if the law had already changed? And that's where we're trying to talk through with managers now. What if you weren't allowed to just dismiss them though? Because we need to start getting into that mindset sooner rather than later, really. And this is the purpose for the QR code. That should have really popped up later. But training. So the QR code there will just take you through to our training and events page on our website, because we do have some fully funded training. Now it is specific for Greater Manchester businesses, so I appreciate some of you are going to not be in the Greater Manchester areas, but if your business has a Greater Manchester postcode, you could have a fully funded place on the training. And we've got 2 courses. One of them is HR for non-HR, so looking at things like the compliance, the policies, the procedures, employment law, that kind of stuff. The other one is a strategy, so thinking about actually the longer term people planning, aligning people's strategy to your organisational strategy. So there's some really good stuff in those. I'm not delivering it. My wonderful colleague Jill is delivering those. And if you would like to come along, they're running next week, which is probably a bit short notice, but they're also running the week after. So you might still have time to get booked onto those, because making sure key managers in your business have the relevant management training and also employment law training is going to be really key, because they're going to need to be aware of these changes, but also aware of the risks if they get it wrong. And obviously budgeting as well, making sure that you're aware of the cost increases and reflecting that in your budgets. So final non-labour update, non-labour related. I want to do a very quick minute on this, just because it came in very recently, about a month ago, the 26th of October 2024. So you may have already done what's needed to comply, but I keep speaking to businesses who haven't yet. So it's just really important because it is already in. New duty to prevent sexual harassment in the workplace. It's a legal duty, so every employer has to do it. I've had to do it. Everybody has to do it. We've got to take preventative steps. So not just have a policy that deals with harassment after it's happened. We need to have proactive stuff in place. So a policy which specifies what sexual harassment is, giving examples of what that is so that people are aware. Setting out a zero tolerance approach is really key, making sure that people know that there will be serious consequences if they do harass others. Making sure everybody is trained, not just managers, but every staff member is trained on sexual harassment awareness, because again, a lot of the harassment issues that we come across is non-intentional, but it doesn't get away from the seriousness of it, nor does it get away from the liability. Risk assessments, making sure that we're aware of the areas of the business where harassment is more likely to occur, things like where people are customer facing, dealing with members of the public, where they might be working on their own with members of the public in particular, where they might be going out visiting sites, going to conferences, all of that kind of stuff. We need to be risk assessing and trying to protect people from harassment from those events as well. And make sure we're actually then taking steps. So make sure people have got clear reporting. If they do have a concern when they're out and about, who do they ring, what happens, who should they report it to? Make sure there's that open door policy. We don't tell people to just accept harassment or to toughen up or any of those things that we see happening, unfortunately, quite frequently. And it's particularly relevant because it's the joyous season of Christmas parties, which is a HR person's favourite time of year. But it does mean that we need to protect people when they're going on the Christmas party from colleagues and other people as well. So that awareness is absolutely key. So if you go on the TUC website, there is a free template risk assessment that you can use, so you don't need to start from scratch. And there is further guidance on the Equality Human Rights Commission website as well. If you're struggling to comply, it'll get your head around that. It's really important to make sure that stuff is done on that one. Conscious that I've gone on, I'm done. So if there are any questions, more than happy to answer them if I can.
Yeah, if anyone's got any questions, you can either unmute yourself and shout out, put your screen on, put it in the chat box, any way you want. But in the meantime, what I'm going to do is thank everybody for joining us this morning. Thank you for joining us throughout 2024 and look forward to seeing you on next webinars in 2025. We hope to have a good new series of interesting stuff for you to watch and listen to. And again, if you've missed anything previously, go to our YouTube channel at Harts Limited, and you'll be able to catch up on anything that you've missed. Again, if you want to give us any suggestions of any other webinars you'd like to put on, then feel free to get in touch. Emma's details are on the screen there. If you want to contact her, if you've come across anything or you've heard anything today, I'm sure she'll answer your questions. Or we're just going to stay on after the recording for a few minutes if anybody wants to ask any other questions at that point. So in the meantime, I'm going to bring this to an end and wish season's greetings to absolutely everybody, whatever you're celebrating, and look forward to seeing you soon.